know any fishermen? How big did they tell you the last fish they caught was?
Oh, okay.
Then you saw the picture. It's right there, yeah. One of the things that we dote on at our practice is making sure that our clients participate in their defense. You know, you were there that night, I wasn't, and oftentimes when a detail comes out about a matter that may seem like a red herring to many, it actually proves to be a defense for us. Now at the same time, we don't want to check our common sense at the front door and assume that any oddity or any perceived oddity in a case ultimately results in the possibility of a dismissal. And we want to go through a few examples of things that people come into the office, invoke as a defense, and unfortunately I have to tell them, come on brah, that won't work. First, the officer never read me my rights. Now, I kind of get this one. This is one where I'm not completely offended that people bring it up as a potential defense, and the reason being, we all turn on the television. We all see Lenny Briscoe throwing the cuffs on somebody, saying something snarky, and reading them their rights.
You say?
You fellas want to read me my rights?
You have the right to remain silent. You have the right to have your face kicked in by me. You have the right to have your balls stomped by him.
I'll waive my rights.
At the same time, Miranda really doesn't come into play that often when it comes to a criminal prosecution. Here's why it oftentimes doesn't amount to a defense. When we are talking about Miranda, we are talking about a post-custodial interrogation, meaning you are already under arrest. Think about the gray room in criminal intent. The lights are on you and they are asking you where you were on such and such a date of last year. Here's why it typically doesn't come into play. First, they're typically not asking you about what you did that night. They already have some level of probable cause, at least in their belief, to lock you up in the first place. This is usually about something else. Secondly though, when people bring it up and say, don't they have to throw the case out, he never read me my rights, that's not the remedy. The best remedy when you should have been Mirandized and you weren't, and then they ask you questions, is simply to suppress the answers that you gave to those questions. So it's not a cure-all. It's not a remedy that results in dismissal. At best, we are talking about suppressing evidence, and I handle so much DWI, most of the evidence is obtained pre-arrest. Secondly, oftentimes people will say, yeah, I was charged with DWI, but look at how that blood screen came back. I was prescribed those meds. Understand it. You paid a doctor a lot of money to give you advice as to how to make your health better, but that doesn't mean you should have been driving. And I gotta tell you that my worst DWIs with respect to fact patterns often are the prescription meds, and that's because people leave the house taking the dosage, maybe on an empty stomach when they typically eat beforehand. 2 miles down the road, it hits them like a freight train, and they've slept through 6 cycles of green light. The prescription med culture has gotten very ugly when it comes to DWI, and even being able to say, well, I took it in its lawful dosage, that doesn't absolve you from responsibility. All that does is maybe serves as a mitigating factor. Next, and this one's always been a little curious to me because the level of planning it would take to have this in your car and plan on drinking and driving is absurd in and of itself. I had a bottle of liquor in the car. When the officer came up after pulling me over, I was chugging it.
You fellas been doing a bit of boozing, have you?
Bad move for multiple reasons. First, the likelihood of consuming alcohol at that time to be absorbed, not rejected, meaning throwing it up, and then reflect on the intoxilizer, which is the machine that they put you on downtown, in a way that would show that you were legal at the time is almost non-existent. Think about it. That result comes back at a 0.15. 0.15 when you get downtown, it doesn't mean you were a 0.07 on the side of the road. No, that means that you were probably a 0.12, and oh, by the way, now you have an aggravated blow because you're over 0.14. Secondly, when you get pulled over, you still have dominion over your vehicle, and North Carolina does not view operation as simply moving the vehicle. If you have control over it, the ability to operate it, that's going to qualify as operation. Third, the behavior itself is indicative of impairment. Who's chugging a bottle of Wild Turkey after an officer pulls him over for suspected DWI? Next, the officer wouldn't show me his radar after citing me for speeding. The logistics behind him taking you from your vehicle back to his vehicle to show you a number on a device that you know nothing about is absurd. This falls under the same light as the officer wasn't wearing his hat like he was supposed to with his uniform. when he cited me, and that should be a dismissal. And lastly, anything sovereign citizen related. Now, me even mentioning them is affording them more attention than they deserve.
You're not a U.S. citizen.
I was not born in Washington, D.C. or any territory of the under federal jurisdiction, so no, I'm not a U.S. citizen.
Were you born in the United States, America, and any
I was born in America. Yes, I'm a state citizen. Idaho?
Idaho? Can I see your Idaho state license?
No, I don't have one.
You don't have one?
My person does, but I don't. And I don't wish to create joinder with you.
These are people that don't believe that the laws that the rest of us live by apply to them when it is something that negatively affects them. When it's something that positively affects them, they're all about it. Filing false tax liens on innocent landowners, applying for benefits. Yeah, sign me up, every one of them saying that. But when it comes to paying taxes, insuring their vehicles, getting licenses, no, that's something they don't have time for, and they derive their authority on in about 10 different ways. The one that is the most prominent is that once we switched to the gold standard and went to a system of full faith and credit to back the US dollar, it made all of us enslaved. Frankly, it's ridiculous. And when you go into court with this in the arsenal, and this being the thing that is going to walk you in your mind, things are going to go way, way south.
Please step aside. I'm going in.
No, you're not going in.
Don't touch me.
You're not going in, sir.
Let the record show that you just battered me,
Step back.
and you're using...
Greatest indicator that even those that espouse to believe in the system don't actually believe in it, they show up in court. They actually show up to the very authority that they say does not preside over them. It's ridiculous. Don't buy into it. If anybody tells you that that's a legitimate defense, they are wrong. And look, everyone's heard these war stories, and sometimes you hear them from people that you actually respect. It's tough not to buy into them. But it is very important that you speak to somebody who actually knows what they're doing before you put every ounce of your defense into things that are, for lack of a better way to say it, fish stories. And that's why it's critical that you get sound legal advice before going to court, or even worse, hiring someone with a bar license who tells you that these are effective defenses.